Good afternoon, everyone, and welcome to day 4 of the 2021 ACS National Convention. My name is Rashad Green, and I'm the current president of the ACS Tampa Lawyer Chapter. And I'm delighted to be here with you today, and it is my privilege to present the 2021 American Constitution Society's Progressive Champion Award, which recognizes extraordinary efforts to ensure that the law is a force to improve the lives of all people, to protect the Constitution, and to develop the next generation of leaders. In recognition of its important work securing voting rights for returning citizens, this year's recipient is the Florida Rights Restoration Coalition. My grandfather, the Honorable Joseph Woodrow Hatchett, the only African American to win a statewide election in Florida besides President Obama, often preached of the importance of active participation in democracy. In 1976, speaking on the issue, he said, quote, "We don't need any more sit-ins. We need work-ins and we need vote-ins. And there needs to be more said about patriotism and democracy, because I think that democracy works to the extent that people work in it." At a time when voting rights are being challenged in my home state and nationwide, the important work of the Florida Rights Restoration Coalition and its president, Desmond Meade, could not be more critical. Under Desmond's leadership, the coalition accomplished what most considered impossible. It led the largest expansion of voting rights in our country in 50 years, amassing more than 750,000 grassroots signatures, enough to add a proposed constitutional amendment to the ballot. The coalition's amendment, popularly known as Florida's Amendment 4, surpassed the threshold of 60% required to become part of the surpassed the 60% threshold required to become law, and restored the rights to 1.4 million formerly disenfranchised returning citizens. And now, having won that battle, their fight is not over. Seeking to maintain restrictions on the right to vote, Florida lawmakers have required that all fees, fines, and restitution be paid in order for the right to vote to be restored. The Florida Rights Restoration Coalition has set about paying off millions of dollars on behalf of these returning citizens. And if that's not working in democracy, then I simply do not know what is. And therefore, it's with great humility and gratitude that I stand before you today to present the 2021 ACS Progressive Champion Award to the Florida Rights Restoration Coalition and its president, Desmond Meade. Desmond.
Thank you so much, Rashad. On behalf of the Florida Rights Restoration Coalition, I want to thank the American Constitution Society for recognizing the work that we have done here in Florida. And like Rashad mentioned, that, you know, we helped spearhead the movement to pass Amendment 4 in 2018. And here we are still in 2021, still fighting to make sure that the freedoms that Amendment 4 guaranteed to 1.4 million returning citizens are actually realized. You know, I did have what I thought to be a decent acceptance speech for this beautiful award here. But, you know, right before we got on, I was looking at the award and looking at how beautiful it was and how it reminded me of a teardrop. And that just totally reoriented my thinking to really wanting to talk about the tears that's involved in this. And when I'm talking about tears, I'm really talking about the fact that the work that we do as practitioners, the work that we do as lawyers and advocates, at the end of the day, is centered around real people from all walks of life and all political persuasions. And we understand the importance of placing people above politics. You know, it's the story of real people that keeps us going. There's a story about, you know, how being disenfranchised impacted so many lives. And I wanted to share the story of Barbara. Barbara was a young lady who we ran across as we was trying to register returning citizens to vote, and she had outstanding fines and fees and couldn't register to vote. But we were able to navigate those waters and make her eligible. And as she was filling out her voter registration form, she started crying. And when our organizers asked her why she was crying, she said because for over 24 years, she's been trying to register to vote, but she gave up thinking that she would never be able to vote because of her prior felony conviction and her previous drug abuse. But here she was that day actually filling out a voter registration form. And as she signed her name at the bottom of the form, she looked up and she asked the organizer to pray that God would allow her to live long enough to cast the ballot. Now, when I was told that story, it struck me right in the center of my heart, because here we had a person, which we didn't know at the time, but her doctor had given her 6 months to live. And her dying wish was not to meet a celebrity or visit an exotic location, but rather just to get to feel what it felt like to be an American citizen, what it felt like to be able to participate in democracy. And Barbara is not an anomaly. Her story is indicative of millions of citizens throughout this country, and definitely hundreds of thousands of returning citizens in the state of Florida who want to be a part of our society. And the way that they feel a part of our society is being able to have the right to vote and participate in elections. And that's why we do the work that we do, because we know that when we are allowing people access to our democracy, we're giving them hope, and we are legitimizing their existence, not only as a human being, but as a citizen of this country. And so in that spirit, in the spirit of the tears that was shed to get us this far, in spirit of the tears that are still to be shed in us continuing this work, I want to just thank ACS for this award, and just know that Florida Rights Restoration Coalition, we would not stop, we would not be denied, and our response to voter suppression is aggression. And if folks want to limit access to democracy, we're going to be fighting 10 times as hard to make sure that every American citizen have free and unencumbered access to the ballot box. Thank you once again.
Congratulations, Desmond. Thank you for those moving words, and thank you for your leadership and the courageous work of the Florida Rights Restoration Coalition. Hello, everyone. I'm Christopher Wright DeRocher, Senior Director of Policy and Program here at ACS. Today's panel will discuss the Constitution in Exile and will be moderated by David Cole, the National Legal Director of the American Civil Liberties Union. David oversees the ACLU's Supreme Court docket and manages the organization's 140 staff attorneys. He has argued many cases before the Supreme Court, including Masterpiece Cake Shop and last year's Bostock v. Clayton County, which held that Title VII bars discrimination on the basis of sexual orientation and transgender status. He is on leave from Georgetown University, where he has taught constitutional law and criminal justice since 1990, and is the Honorable George J. Mitchell Professor in Law and Public Policy. Welcome, David. I'll turn it over to you to introduce the panel.
Thanks so much, Chris. Great to be here with everybody and with this esteemed panel. I'm going to introduce the panel briefly and then have a few introductory remarks, and we'll go right into the conversation, and it will be a conversation. So we have a remarkable group here ready to discuss the Constitution in exile and how we might get it out of exile, and from a variety of perspectives. So first we have Katie Iyer, who is a professor of law at Rutgers Law School, an expert on anti-discrimination law, LGBT rights, author of a very important and influential article on statutory construction and LGBT rights, which predicted really where the Supreme Court would come out in the Bostock case last term that extended Title VII to discrimination on the basis of sexual orientation and transgender status. Jamal Green is a professor at Columbia Law School, focusing on constitutional law and comparative constitutional law. He is just out is his book, How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. And so I hope we'll hear a little bit about that thesis today. Cindy Suhu, who is a professor at CUNY Law School, where she also runs the Human Rights and Gender Justice Law Clinic, and who is particularly has expertise in the area of reproductive freedom. And finally, Franita Tolson, who's a professor at USC Law School and the vice dean there, an expert on election law and civil rights, and the host with Ned Foley of the election-themed podcast Free and Fair with Franita and Foley. So a little heavy on the law professors here today, but we'll do our best. Let me first say that for those of you who are interested in getting CLE credit, we will post a link in the chat box at the end of this session that will take you to a Google form that you must complete in order to obtain credit. You will be required to provide 2 codes in order to fill out that form correctly. I'm going to provide the first code at the midpoint of this panel and the second code at the end of this panel. You will need to provide both codes to obtain credit. And then we're going to have a conversation here for a period of time, but we will then go to your questions in the latter part of the time we have. And so we encourage you to be active participants during the panel. Please use the live comment section on YouTube, which is located on the right side of this page, via Facebook if you are watching there, or on the ACS website to share your remarks and questions. I will select as many questions as I can during the last section of our conversation. Please note that in order to comment, you need to be logged into your Facebook or Google account. So that's it on the formality. So, what are we talking about here today? The title is The Constitution in Exile. That is a term that is attributed to DC Circuit Judge Doug Ginsburg, who argued in a 1995 article that certain constitutional constraints that were originally intended had gone under enforced or unenforced and needed to be brought back into the constitutional picture, especially Commerce Clause limitations. And it really, I think, has become kind of shorthand for the campaign led by the Federalist Society and by leading conservative thinkers, jurists, and activists to attack the administrative state through a variety of constitutional tools, whether it be renewed Commerce Clause limitations, reinvigoration of the non-delegation doctrine, originalism, as a method for interpreting the Constitution, the Appropriations Clause, the Appointments Clause as a method for limiting the existence of independent agencies. Even some First Amendment arguments have been advanced as deregulatory tools, and this has been, this has been a long-term campaign. We're now 25. If you date it to 1995, when Judge Ginsburg wrote his article, you're talking 25 years. I think the effort started a little bit before that, maybe even 10 years before that. And so it's a long-term strategy, and it's a strategy that has made some significant progress Although I would say really remains to be seen how successful this will be, how radical the reforms will be in terms of sort of cutting down the force of the federal government and the administrative state. I think the jury is really very much still out on that, but it's within range in a way that it was not within range before, say, Donald Trump got elected. But of course, Donald Trump did get elected. Donald Trump then appointed 3 justices on the Supreme Court and many judges on the federal courts of appeals and the district courts. Without the filibuster, he was able to really rush through a remarkable number of unprecedented number of judicial appointments. And so, we on the liberal side of the spectrum face a challenging legal terrain. Those of you who are new lawyers, lawyers to be, those who are old lawyers and believe in our Constitution, may well feel that our Constitution, if not in exile, is on the precipice of being deported. And our Constitution, by our Constitution, I think there's a question what that is. I would say our Constitution is a Constitution that is designed to protect those who cannot protect themselves through the political process, that is attentive to the need for independent courts to protect the marginalized, members of minority groups, dissidents, the disempowered, and we're going to talk today about how those who care about that Constitution, that constitutional vision, ought to proceed in a world where there are many judges and justices who may not share that view at this point, in a world where 70 million Americans voted for Donald Trump, even though he quite clearly lost the election because so many more voted for Joe Biden. I think the questions include what sorts of arguments should we be thinking about? How should we frame our arguments? What sorts of tactics should we be considering? What forums are important? How do we approach a 6-3 conservative Supreme Court when we are before the court? I suppose on the table also is the question of court reform, although I think that our panel will focus on assuming, which I think is a proper assumption, that there won't be court reform, at least not in the short term. What do we see? So next Supreme Court term, we will have some very likely have some early indications of what we're going to expect. As people know, the court has granted review in an abortion case. It has granted review in a case challenging New York's requirement that people show a special need to be able to carry a concealed weapon. There's I think better than 50-50 chance that it grants review in the Harvard affirmative action case. So you could have a term in which abortion, guns, and affirmative action are all front and center. That will be a big term. So I want to start us off by talking about abortion. The court granted review in Dobbs versus Jackson Women's Health Organization, a Mississippi case involving a ban essentially on any abortions after 15 weeks, absent risk to the health or life of the mother. The question presented is whether all pre-viability prohibitions on elective abortions are unconstitutional. Whether all pre-viability prohibitions on elective abortions are unconstitutional. So Cindy, tell us what's at stake in this case. What are the possible outcomes that we might see?
Thanks, David, and thanks for inviting me to be part of this conversation. After avoiding abortion cases for a long time, the Supreme Court is set to hear its third major abortion case in 5 years. And I think this really shows the instability that's been created by the politicization of Supreme Court nominees, especially around overturning Roe versus Wade. Since Roe versus Wade, almost 50 years ago, it has been settled law that pre-viability, that the state cannot ban abortions pre-viability, and that women and pregnant people have the right to choose, the ultimate right to choose whether or not to end up the pregnancy. In 1992, in Planned Parenthood versus Casey, the Supreme Court gave the state a little bit more room to regulate the provision of abortion, the why and how in terms of how abortions are performed. But and the question really was whether those regulations imposed an undue burden on abortion. And after Casey, it became almost a cottage industry for states to pass laws, making it more and more difficult for people to access abortion as a practical matter, even as they retain the legal right and to choose abortion. And particular at issue were trap regulations, and these were targeted regulations of abortion providers that made it that only applied to the provision of abortion, didn't apply to other health services that were essentially of the same risk, and really had no health purpose, and were really designed to make it too costly or impossible for abortion providers to comply. And the issue had been, what test does the court apply to determine whether these regulations are undue burdens? And just 5 years ago, in 2016, in Whole Woman's Health versus Hellerstedt, the court clarified the standard, and it struck down a trap regulation. And initially, the lower courts applied the standard. But after Justices Gorsuch and Kavanaugh joined the court, we saw greater lower court resistance to applying the standard. They were, rather than applying the standard, they were really anticipating the changes at the Supreme Court. And then last year in June Medical, which was one of the last cases that Justice Ginsburg heard, the court actually heard a case involving the identical regulations to the regulations it struck down in Whole Woman's Health versus Hellerstedt. And although Justice Roberts, in a concurrence, provided the fifth vote to overturn this regulation on stare decisis grounds, his reasoning actually rewrote the standard that the court actually applied just a few years ago in Whole Woman's Health versus Hellerstedt. And what we're seeing now with the new conservative majority and the appointment of Justice Barrett is that there's a rush to pass laws not only about what constitutes an undue burden, but laws that really go to the heart of Roe versus Wade and go back to this issue of whether the state can actually ban an abortion pre-viability. And right now we've seen actually 165 bans that have been introduced by state legislatures, and 10 have actually passed. So I think, one thing that we need to think about is just how the politicization of the court has really created this instability and this place in which the court is really reversing, not only reversing its decisions on the undue burden standard, but really going to the heart of Roe versus Wade.
So, and do you have a sense of sort of what are the range of outcomes that we might expect the court to hand down a year from now? Because it will be a year from now when we get the decision. I mean, I suppose they go from overturning Roe altogether, right? To saying there is no the due process. Where in the Constitution does it say anything about protecting abortion? That's the most extreme, and then the other most extreme is we win. All right. So my guess is that they're going to come down somewhere in the middle there. So what are the middle options?
Well, I don't think quite in the middle. I feel like, more. I think like one thing we need to be attentive to, right, is that Roe and Casey are really key cases in the sort of substantive due process line of cases, right? So if Roe and Casey go, I think that there's going to be a real threat to this idea that individuals have a liberty right to make personal choices that impact their lives and their futures. So where is the Supreme Court going to go? It's interesting, right? Because this viability line had really created sort of a concrete standard, right? So if we get rid of viability, what's going to be sort of the new bright line? I think that's really an open question. I think the Mississippi law is 15 weeks, so I think we're going to see. I think that the Supreme Court could say that this Mississippi law is constitutional, and then we'll see sort of an open season where states are going to try to ban abortions earlier and earlier, right? So we've seen like states pass laws at 6 weeks and some at conception. 6 weeks is actually probably before a person even knows that they're pregnant. I think we're also going to see the court consider laws that try to restrict the reasons why a person has an abortion. And this has always been, it's been well settled that a person can have an abortion for any reason prior to viability. So I feel like these are going to be all the questions that are going to be opened up.
And so we have a year until we will learn the result of this case. Is there what can folks do between now and then?
Right.
Who care about the right, beyond filing amicus briefs or calling the Center for Reproductive Rights and offering them ideas for arguments that will persuade 5 justices. What can and should folks do who want to minimize the chance of a bad decision?
Right. Well, I mean, I think for the litigators at the Center for Reproductive Rights and the ACLU and other litigators who are working on this case, working on these issues, I think, on the one hand, I think that we need to be defensive in terms of trying to preserve what we can of Roe v. Wade, right? And thinking about maybe Justice Roberts' view about what the new standard could or should be is not going to be as extreme, and thinking about how to build off of his decision in June Medical. But I think we also need to play the long game and develop alternative legal theories to protect reproductive rights and justice that would be more consistent with the way the public actually understands the issue. And I think thinking about not only making sure that abortion is legal, but also accessible. I think that that's actually important for the broader public, and also that we're protecting people's ability and supporting people's ability to choose to have children. I think we should be developing those theories. I think we can be thinking about, as we develop these theories, maybe trying out state courts where that might be more protective, or where there might actually be affirmative government obligations to protect rights. I think that the other thing we have to do is we really need to mobilize and recognize that the majority of the country is not anti-choice. 77% of people polled do not favor overturning Roe v. Wade. So I think we really need to be active, mobilizing legislatively to stop the passage of bad laws, to pass laws that actually could codify Roe v. Wade. There's the Women's Health Protection Act, which would do just that, but also thinking about passing laws that would ensure that people have access. And so people have also been working to ensure that there isn't discrimination in insurance or Medicaid coverage for abortion. So I think these are the kinds of things we should be thinking about.
And how much does the availability of medication abortion change the dynamic in terms of the reality of women's access to abortion, whatever the court decides?
Yeah, I think medication abortion is going to be is a game changer, right? And to the extent that we're looking at a potentially post-Roe world where, maybe more than half of the states are going to try to ban abortion or restrict it to very early in pregnancy, I think expanding access to medication abortion and telemedicine is going to make a big deal in terms of people's access. I think we should be thinking about providing funds to abortion funds, which are set up in states where it's already difficult for people to have access to abortion, to ensure that people can actually get the financial assistance that they might need to travel. One thing I think we also need to be aware of is, once medical and clinical abortion become illegal, more people are going to self-manage their abortions, right? People are actually able to get pills in order to cause a medication abortion over the internet, and we need to ensure that people can, and this can be safe as long as people have access to reliable methods and information. So we need to make sure that people who are using self-managed abortion can do it in a safe way. And then the other thing that I think that's going to happen is that these people are at great risk of being prosecuted. So, we're sort of not in the wire hanger days, but we're in a world where, with overcriminalization, that people who self-manage their abortions may be prosecuted. And actually, if when How actually has launched a new fund actually to support the representation of people who might be criminally prosecuted for abortion. So I think those are the other things that we need to be thinking about as lawyers, making sure that when people self-manage, which they will, that there will be defense for them if they're criminally prosecuted.
So thanks. So Jamal, I think you may have wanted to come in here on how the self-managed care reality affects the arguments.
Yeah, I wanted to, and everything Cindy said was I thought was exactly right. And I just wanted to just emphasize this point about choice and choices and the reality and the predictable reality that self-management is going to happen. We tend to think of sort of pro-life and pro-choice as being these, opposite sorts of things. But, if one is serious about being pro-life, then there should be much more focus on giving women genuine choices about whether to choose to become parents or not. In a number of other countries, and most prominently Germany, courts have been really integral in requiring that as a necessary component of any restrictions on abortion rights. If you're going to make abortion more onerous, you also have to marry that to providing family leave, to providing employment guarantees, providing childcare, providing prenatal and postnatal health services, so that you can't, if you're going to violate women's autonomy, you can't do that certainly without also giving choices that makes it more likely that they're going to choose childbirth. And in the U.S., right, the most strongly anti-abortion states also invariably have the least generous leave policies. And I think there's more work to be done, I think, in emphasizing that that's not a pro-life legal regime, right? So the argument that, being pro-life requires you also to be in favor of giving people choices, I think can resonate with some constituencies.
So, and I could see how it could resonate with some political constituencies. I find it hard to see how our Supreme Court, within our constitutional tradition, would find that the states are required to provide affirmative assistance to. I mean, haven't they rejected those arguments time and time again?
Yeah, so I'm not suggesting that the court's going to accept that argument, a sort of German-style argument that the state is required to provide certain services. But as we all know, the line between law and politics is not so stark, right? So if the environment in which one is confronting a law like the law in Mississippi is one in which it's emphasized that Mississippi, among many other states, is not very generous in providing women with genuine choices, it puts this kind of restriction in a different light. And I think that does have an impact on people, or potentially does.
Right. So Cindy, back to you on sort of, one way of viewing all of this is that 50 years ago, the Supreme Court decided Roe versus Wade, thus launching a 50-year movement for social and constitutional change that has succeeded to some degree, right? It has not succeeded in terms of what they want, which is to overturn Roe versus Wade. It failed most dramatically in Casey, 20 years after Roe, to overturn Roe. It has succeeded in watering down the right. It has succeeded in making it more and more difficult for many folks to access the right. And one can imagine that if the court were to decide, let's say the court were, I think it's unlikely, but the court were to decide Roe versus Wade is overturned, a decision that 77% of the public is against, would be against. That's one of the reasons I think it's unlikely it will happen, because the court doesn't generally do things that 77% of the public is against. And if you started seeing prosecutions of women for obtaining abortions, not a good look for their side, you could see a real ramping up of political action on the side of pro-choice that would, be remarkable. So I guess the question is sort of what should pro-choice advocates learn from the 50-year lesson that the pro-life movement has provided us?
Yeah, thanks for that question. I feel like, it's a question both what can we learn from the anti-choice movement, but also what can we learn from the reproductive justice movement? I feel like, the reproductive rights movement has been sort of narrowly focused on the constitutional right to abortion. And I think there are lessons that the reproductive rights activists can learn from the reproductive justice movement. But in terms of just thinking about the sort of this long-term strategy to overturn Roe versus Wade, I think some aspects, and I'm not saying that we should actually adopt all these strategies because some of them I think are problematic, but I think there was a refusal to accept Roe versus Wade from the very beginning. I think in conservative circles, despite the fact that it was established precedent, there was continued to be strong dissents, the building of constitutional theories, and just a constant push. Right, even when Roe was well settled, and so there's this constant challenge, right? And there's been a constant creativity and the sheer variety and volume of bills designed to test Roe v. Wade over the years has really been tremendous. And there's actually, and the creativity, relates to the trap laws, and also there's a new Texas law that we can talk about later, which I think has legal academics and litigators really scratching their heads about how we can actually challenge it. But there's also been, I think, a strategic cynicism in terms of, even when they knew they couldn't overturn Roe versus Wade, passing laws that de facto made it impossible for many people to access abortion. And I think there's a parallel to voting rights, right? This idea that, Roe versus Wade wasn't overturned, but we're just going to put more and more barriers so people can't actually access it. And in some ways, I think that was an incredibly successful strategy because a lot of people didn't politically mobilize because Roe versus Wade wasn't overturned, right? Even though for many people, they couldn't, as a practical matter, access abortion. I think that the right has been incredibly successful in developing pipelines to, they're incredibly creative about creating these new bills and then just sort of farming it out to state legislatures. And a lot of times, the legislators don't even know exactly what the law does. They only know that it's going to get them like a check, amongst their pro-life constituency. And then I think the other thing that, they've been great about is integrating their world vision with and their messaging and their communication and their legislative strategies. And they've done this in terms of passing bills to protect their view of fetal life, right? And so the newer bills are banning abortion at 6 weeks or 12 weeks because of fetal heartbeat or fetal pain. There's no scientific evidence for either of those things, but it doesn't really stop them because that's sort of their vision. They want to talk about the fetus and try and humanize it, even though it's not supported by the science. But sort of the drumbeat of these messages over and over, I think, really have an impact on the public at large and constituencies. So what we should do, I think we really need to adopt our own constitutional vision that people can get behind. And I think it has to be a robust vision that, again, really is about people's meaningful access to reproductive justice and the full range of reproductive choices. And really give people something positive to get behind. And like Jamal said, I think that, in some ways, they've been incredibly cynical in terms of talking about pro-life and yet not really creating any opportunities for people to choose to parent, right? And I think we need to really try to make sure that we're not just about creating legal rights, but that all people have access to the rights.
Thanks. Yeah, I think Roe and its the response to it just underscores the point that, in some ways, the Supreme Court is, we talk about it as having the final word. It never actually has the final word unless people let it have the final word. And so, civil rights folks did not let the court have the final word on Plessy versus Ferguson, and the pro-life folks have not let the Supreme Court have the final word on Roe versus Wade. The LGBT movement did not allow the Supreme Court to have the final word on its early anti-LGBT decisions. Ruth Bader Ginsburg and the women's rights movement did not allow the Supreme Court to have the final word when it said that Equal Protection Clause doesn't, question laws that discriminate on the basis of sex. And so, I think that's just a really, when we're facing a court where we're going to get some we will get some decisions, more decisions that we're unhappy with than are happy with. I think it's important to keep in mind that they are not the final word, unless we let them be the final word. So I want to shift now to the area of LGBT rights, because that's an area in which, the final word has definitely not even been provided by the court, but where, the LGBT movement has really made, tremendous strides in a relatively short period of time, in terms of the history of our country, on achieving equality. If you take decisions like Romer and Lawrence and Obergefell and Bostock, that's a pretty darn good record under a conservative majority Supreme Court. Every one of those decisions was handed down by a conservative majority Supreme Court. So, and right at this moment, we're seeing a lot of pushback, right? In particular on trans rights, and particularly they're focused on medical care for trans folks and bans on trans women playing and trans girls playing girls and women's sports in many states around the country. But Katie, what do you take from the fact that the LGBT movement has had such success with a conservative majority Supreme Court, and what does that make you feel about the future with respect to some of the current attacks that we're seeing?
Thanks, David. That's a great question. And I mean, what I'll say is that what I think this really emphasizes is something that's already been alluded to quite a bit on this panel, which is that fights over rights are a long game, and they're a game in which the Supreme Court is not the only actor, right? And in which we can't necessarily assume that the court will simply follow predetermined ideological predilections. And that's because, of course, we have, as you surely know, social movements who are doing this work, right, out in the world at all sorts of levels. And if you think about some of the major victories we have, you think about cases like Obergefell or cases like Bostock, they may seem to some people like the Supreme Court just sort of stepped in and saved the day on this issue. But of course, there were decades and decades of work that preceded that, a lot of it done by folks like the ACLU, Lambda, NCLR, others, to set the stage for that and to help sort of move along our public legal culture such that those decisions became possible. And that was work done in the lower federal courts. It was work done in the state courts. It was legislative. It was local legislation, right? So all of those pieces were important to reaching a point where the court could arrive at the decisions that it did in those cases. So I think that's a really valuable insight for this moment in time, that just because what you see at this current moment is an array of justices who may not seem favorable to a particular issue doesn't mean that the work isn't important and that it won't have an impact down the line. So
thanks. So let me take one break here, and this is the official CLE break, where you are those in the audience who want CLE credit are told the secret code that you are supposed to write on your form, and that is Federal 5, capital FEDERAL, the number 5. So back to the conversation here. Many of the challenges, it seems to me, when I look at the marriage equality movement, I see a situation in which the folks on our side who are seeking to advance equality could really set the agenda, right, by where they brought cases, how they brought cases. That there were gay and lesbian folks all in every state in the union who wanted to get married, and a lot of the work of the of lawyers in this field was discouraging folks from suing in states like Mississippi or Texas, where you're not going to, you have a very you have very hostile courts, and instead going to Vermont and going to Massachusetts and going to Connecticut and DC and California, right? And but that's not really where we are right now, right? The attacks are being, the agenda is being set by the other side, right? They're picking barring trans girls from girls' sports because they see that as the sympathetic issue for their side. So, talk to me about what we can do when they have the ability to set the agenda and we don't.
That's another great question. I mean, I think there's a few things, certainly the lesson of that what persuades people and ultimately is important to that sort of legal success is seeing the real people who are behind the discrimination. I think that, yes, strategic advocacy was really important in the marriage movement, but so was, millions of Americans getting to know folks who were, in committed same-sex relationships and coming to believe that it didn't actually make sense for those folks to not be allowed the right to marry. And that just sort of made all of the justifications that states had traditionally provided for, limiting marriage to, one man, one woman fall apart when you get to court. And that's just no longer sustainable. People didn't believe the myths about it's bad for children and this is going to be a disaster for society. And I think that actually, both that sort of getting to know the people, and then on the flip side, one of the other things that I think was really important about the marriage movement is in choice of legal strategy, they didn't shy away from strategies that really put on trial the issue of whether the state had a real reason for what they were doing, right? Some of the earliest cases are decided on rational basis grounds. In first year con law classes, students are told all the time, don't bother with rational basis review. It's useless. You won't get anything out of it. But the reality is what you get out of it if the court really listens and you have the record to substantiate it is to really undercut the idea that there's a good reason for the discrimination at stake. And I think if you look at lots of the legislation that's being enacted right now with respect to transgender youth, right, that same type of work can be effective, right? In many cases, the legislative records of these laws really don't support the arguments that are being made in support of them. And in some cases, right, like as in the case of the healthcare bans, really cuts directly against it, the idea that this is somehow protecting kids. So I think that, again, it's a different terrain when you don't get to sort of pick and choose your state with the idea of, I remember that. I remember being in Pennsylvania being like, plaintiff, please don't bring that case, right? It's a different place to be when you're not choosing the terrain, but it is, I think there are still lessons about how to think about that strategically that we can have from the history of what advocates have done very well in this field.
That's excellent. Chase Stangio, who was one of our LGBT lawyers, was recently arguing in the Ninth Circuit a challenge to the Idaho ban on trans girls in sports. And the argument one of the arguments that the state's pushed forward is that women's sports will fall apart, it'll no longer be fair if trans girls and trans women are permitted to play on girls and women's sports teams. And he said, that argument was advanced about tennis when Renee Richards sought to play. They said, this is going to be the end of women's tennis. And here we are, 50 years later, and women's tennis seems to be totally fine, right? So the facts on the ground sometimes can be very powerful refutations of what is ultimately just prejudice. But when your point about reasons and sort of attacking the reasons, I think raises really one of the most challenging areas, and that is the religious refusals context, in which the reason advanced is I have a deep-seated religious objection to celebrating a same-sex marriage. So I can't be compelled to make a cake for a same-sex couple, or I have a deep-seated. I believe in my religion. Abortion is murder, and so you cannot require me as a doctor to perform abortion services, or as a Catholic hospital to perform abortion services. So there, it's harder there, right? To just, the reason can't be rejected as completely unsubstantiated, right? It's not like, look, that women's tennis is all well and good, notwithstanding Renee Richards. What's the best strategy here? And I know there are a number of folks on the panel that want to weigh in on religious refusals, but how do we deal with this form of attack on LGBT rights?
Yeah, I mean, the first thing I'll say is that, traditionally there has been some accommodation for religion in anti-discrimination law. And I think what folks within the LGBT rights movement have been pushing for is simply that accommodation be the same for anti-LGBT discrimination as it is for all other protected groups, for example, under Title VII. But the other thing I'll say, I mean, I do think there's both sort of a public relations fight going on here and a legal fight. And I will say that I think the progressive side is not doing well on the public relations side. I think that there is a sort of increasing sense that, folks who are religious are being persecuted in a certain way. And that's important to attend to, that piece, just as much as the legal piece. What I'll say on the legal side is I think it's important to parse out the different types of religious liberties arguments, right? We're not always talking about the same type of religious liberties defense at issue here. For RFRA, there's a key issue that remains open. So the Religious Freedom Restoration Act, which is how some of these arguments are made. There's a key open issue that's just in dispute in the lower courts about whether private plaintiff lawsuits can be defended with a RFRA argument. That's a key legal issue that could really limit the impact of RFRA on its ability to interfere with the application of anti-discrimination law at the federal level. We've got the Fulton case coming on the free exercise side. I was a Fulton optimist at the time of oral argument, and we've since had this series of per curiam decisions, which I think make it a little less likely that we'll see the city of Philadelphia win in that case. So for those of you who are watching who don't know this case, it involves the city of Philadelphia terminating their contract for the placement of children for adoption with Catholic Social Services because Catholic Social Services said they would not serve same-sex couples. And Catholic Social Services is raising a free exercise argument saying that was impinged on their free exercise. There are, of course, still bases on which the court could reach a result in favor of the city in Fulton. But I think what this more recent free exercise doctrine, which has been decided in the context of some of our COVID restrictions on worship, suggests is that public entities need to be really attentive to how they're treating religion and to making sure that if they're giving exemptions to other folks, they're giving comparable exemptions to religion. And if they don't want to give exemptions to religion, then they shouldn't be giving those exemptions to anyone, right? There's a real equality norm and sort of most favored equal norm that's being increasingly introduced into the doctrine.
Thanks. I want to bring Jamal in on this because, as I understand your argument, at least from that I've seen, maybe the city of Philadelphia should win Fulton because one of the defenses one of the arguments that Catholic Social Services is making is there are 29 or so foster care certification agencies that all get contracts from the city to certify foster care families. And so if you are a same-sex family, you won't get certified by Catholic Social Services because they will turn you away. No matter how qualified you are, they will turn you away because you are same-sex. That's it for them. But the Catholic Social Services says, well, but that doesn't stop same-sex families from being eligible to adopt foster care kids, because they can go to any of the other 28 agencies that don't discriminate on the basis of same-sex status. So would you vote in their favor on that theory? You're muted. I think.
So no, I don't. I mean, without getting too deep into the facts of Fulton, I don't think Catholic Social Services' position should prevail there. But I don't think it's irrelevant that there are other alternatives available to same-sex couples who wish to participate in the foster care system. I think it is. I think it's also quite relevant that this is a city agency engaged in a licensing process and not just simply autonomous private actors. And I think that that's more relevant in the case. What I would just add, and I agree with everything that Katie said. What I would just add is, I think it's important to disaggregate religious accommodation from denial of service. There often are situations in which you can accommodate. There are ways of accommodating a religious actor or religious person without necessarily having it result in people having it be more difficult for them to get services. And I think Employment Division versus Smith, which says there's no constitutional right to an accommodation if it's a neutral law of general applicability, is not a progressive opinion and not one that we should necessarily embrace. And that now is really the time, at least in my view, now is the time to be shaping what it looks like for that decision to be overruled. That it need not necessarily look like race-style strict scrutiny. That overruling Smith, which I'm sure lots of justices are chomping at the bit to do, doesn't mean that the city of Philadelphia has to lose that case. In fact, I think it shouldn't mean that. So I think trying to shape what it looks like to lose in that context is really important, and we shouldn't cede that ground to the right.
Thanks. Cindy, do you want to jump in on religious refusals in the?
Yeah, I mean, and I agree with both what Katie and Jamal said, and but I feel like one point to underscore is just that the right has been so clever about weaponizing the religious rights, and what we're really seeing is not. In my view, right, that it's no longer become about a person's right to exercise accommodation for a person's right to exercise their religious belief, and really an opportunity for individuals to take away people's ability to exercise their right to choose in the abortion context, right? And so, like in other countries, like in Latin American countries where there's sort of strong Catholic faith, the way that this conscientious objection right is understood is that it's a right of the individual provider. And although the individual provider can choose not to provide abortion, health systems can't object, right? And that health systems have to ensure that there's actually someone available who can provide the service, because it really you should be able to exercise your religious beliefs, but you shouldn't be able to, in the exercise of your religious beliefs, prevent other people from having access to services that they have a constitutional or human rights right to have. And I think that and in the United States, I think we've stretched this idea of conscientious objection right. So like if you look at the contraceptive mandate, right, it's not about actually the person, which requires that employers provide coverage for contraception. It's not about whether a doctor is going to prescribe contraception. It's not about whether or not the employer is going to pay for the services. It's actually about whether the employer is going to buy insurance that will allow coverage for someone else to choose to get contraception. And it's so attenuated And yet we still, the Trump administration has argued, right, that they need to protect people's conscientious objection rights in such an attenuated circumstances that has real impact on people's ability to access contraception. And I think that really stretches this idea of conscientious refusal too far.
Yeah, no, that's an excellent point. I mean, the whole Hobby Lobby, and contraception debates sort of, it's suggested that, there are ways you can accommodate a religious objection. The scheme in Hobby Lobby accommodated a religious objection, but assured that female employees would still get contraceptive care paid for by the insurance agents. And that was an accommodation, though, that the entity didn't have to provide it. The insurance company provided, but they weren't. That wasn't enough, right?
Right. They said it was too much for them to have to object. Yeah,
to even file the. And so when you get to that point, you're really not asking about accommodation, which is what I think all three of you are talking about. Is that there may be situations in which accommodation can occur, but instead you are talking about refusal. Really, it's a claim of refusals. I mean, I'd love to hear people's take on the sort of analogy to race. Many of we litigated the Masterpiece case, cake shop case, and we were a counsel in Fulton, and if you imagine the same argument being made about race, it seems completely unimaginable that the court would say Masterpiece Cake Shop has a constitutional right to refuse to sell a cake to a couple of mixed race who were getting married because he had a religious objection to mixed race marriages. And similarly, in Fulton, the law in Fulton, the city law that Catholic Social Services objects to, prohibits discrimination on the basis of race, gender, sexual orientation, et cetera, et cetera, et cetera. So suppose Catholic Social Services said, we just won't certify any Black families. Does anybody think that the court would, even take that case? Right, either Masterpiece or Fulton, both of which were cases where the lower courts ruled against the person seeking the exemption. So I often think, if you think about it in the context of race, it just shows how unacceptable the argument ought to be in the context of discrimination on the basis of sexual orientation. But other people think, this is a bad argument, or this is an argument that's just going to piss off the court. So love to hear people's thoughts on the race analogy, the race, sexual orientation, discrimination analogy, and whether it's, helpful, hurtful, why not?
I'll say something brief about this, which is I think it's often not helpful. I think it depends on how it's used. So in the way in which I think it can be used more artfully and less artfully, right? So in the context of Fulton, as you just said, David, talking about refusing Black couples or talking about interracial weddings in Masterpiece Cake Shop is a more precise analogy than it's often the way in which it's often used, which is to say, this is just the same thing as Ollie's Barbecue, or just someone who just refuses to serve a certain customer at all, which is, I think, a different situation, even if it's also, they can both be bad and one can be worse. But I'll also say, I think just generally, and this is a bit of a sensitive point to make, but I do think it's important to recognize the broader factual context of Jim Crow as being exceptional, right? There is within the liberal tradition a protection for a certain degree of dissent, right? So someone who is dissenting from the laws of their state because they claim a bona fide religious objection is differently situated than someone who's participating in a state-supported system of terrorism against a group of people. And we appropriately, I think, view those situations differently. And an individual person who has a bona fide objection to racial to race, to participating in an interracial marriage, I would certainly condemn that person. But that's unusual today, because social and political mores have changed over time. And I think that the solution to that kind of problem is to make it sufficiently unusual that it's stigmatized. But I do think it's important to recognize that there are interests on the side of a conscientious objector, to even if we think that their views are repulsive, and that we view it differently if it's the whole system versus just an individual.
Just to piggyback a little bit on what Jamal was saying, I also think this is interesting in the sense that descriptively, we've seen this play out in another First Amendment context. And what we've seen is that whether or not the court foregrounds it, that difference in context seems to matter to the court, right? So if you look at First Amendment associational rights, the court starts out with respect to race in cases like Runyon versus McCreary saying there is no associational First Amendment right to discriminate, period. It gets to gender and it sort of waffles, right? It says there's such a right, but you get strict scrutiny, and it actually invalidates, every case it hears where there's a claimed right to discriminate based on sex. And then we get to the cases like Hurley and the Boy Scouts case, where the court takes that same set of rights and it's drifted far enough to then allow the discrimination, right? When we're talking in the Boy Scouts case about New Jersey state law, it says, yes, you can have this exemption where the subject is sexual orientation. So whether or not the court should view those things differently, I think we do have some historical evidence that it does view them differently and that it can matter to how it adjudicates First Amendment rights.
I just wanted to just add, I'm not an expert on the LGBT cases, but I don't know how Masterpiece Cake was organized as a business, but I think, the other thing to think about in the reproductive rights context and Hobby Lobby, right, is this, I think it's one thing to recognize that individuals have religious rights, and it's another thing to think about corporations having religious rights. That corporations have a right of religious refusal, which we've seen in Hobby Lobby and the Trump administration regulations about the contraceptive mandate. This idea that corporations actually can say that they have a religious objection to providing contraceptive coverage, I think it goes too far.
Yeah. Great. So let me turn. Thank you for all that. Let me turn to Fernita and the small subject of democracy as part of our Constitution in Exile. We are seeing, in response to the really opening up of voting opportunities in response to COVID, and the loss by the Republicans, a real effort to shut that back down and to make it harder for people to vote and to restrict mail-in ballots and drop boxes and voting hours and the like. Those are being challenged in the courts, but those are very hard to challenge in the courts, right? Very hard to challenge in the courts, and may get a lot harder if the court reads Section 2 of the Voting Rights Act in a restrictive way in the Branovich case, which it has before it, which is interpreting Section 2, essentially the disparate impact provision of the Voting Rights Act. So, what's the recipe for progressives on this front, Fernita?
First, let me say thank you so much, David. Very happy to be a part of this conversation. So when it comes to the courts, I think it's right that the Constitution is in exile. In my lifetime in particular, I don't think there's ever been a time where the courts have been pro-democracy, pro-voting, right? It's always voting rights groups and people who do this work being on the defensive and trying to defend the progress made in the 1960s in terms of the right to vote and protecting the right to vote. In the 1990s, you saw the rise of the Shaw claim, where anytime the state legislature draws a district and race predominates, then strict scrutiny applies. And this is independent of any concerns about vote dilution or vote denial or negative effects. You see an attack on statutes that have disparate impact provisions. In 2015, there was a 5-4 decision where the court barely upheld a provision of the Fair Housing Act, which had a disparate impact provision. So, given that the alignment of the court has changed since 2015 to be a 6-3 conservative majority, the Section 2 case that's before the court this term could be bad, right? And I think in particular, I find it really, really sad that if the court says that, some changes are just too small to be cognizable under Section 2 of the Voting Rights Act, that's a win, right? Because it prevents the court from having to invalidate Section 2 as being broader than Congress's power to enforce Section 5 of the 14th Amendment or Section 2 of the 15th Amendment. So even a bad decision could still be a win for progressives, provided that Section 2 survives to fight another day. So we're in a bad situation, but there is a path forward, I believe. When we talk about the Constitution in exile, far too often we think about the courts and we don't talk about Congress or we don't talk about the states. Congress in particular has an opportunity to be forward thinking on the subject of voting rights. It just really depends on whether or not they can get their stuff together, right? Because HR 1 is still a possibility, which is a pretty comprehensive change to our system of elections, right? It has provisions that would enfranchise those with felony convictions for purposes of voting in federal elections. It expands registration opportunities, including requiring automatic voter registration. It changes the campaign finance rules. It establishes independent commissions to draw congressional districts. So, a really, really comprehensive bill that could have the effect of mitigating some of the efforts that we currently see in states to try to undermine voting rights. And I just want to point out something that's been overlooked in this entire discussion. HR 1 is modeled after successful practices that we've seen in the states, right? People are trying to paint it as this power grab, but in essence, it's really federalism at its finest, right? Because what Congress has done is looked at what states have done in this space and put it in a federal bill to address some of the shortcomings that we currently see in our system. And I really think HR 1 coupled with HR 4, which would give us a new coverage formula for the Voting Rights Act, could go a long way in protecting the right to vote. Because in the wake of the 2020 election, you really do see these state legislatures trying to pass voting bills, that are tailored to negatively impact minority communities. Georgia in particular passed a law where they are restricting absentee ballots while expanding opportunities for in-person early voting, in part because of voting patterns in the 2020 elections. Minority communities disproportionately use absentee voting, and white voters disproportionately use early in-person voting. And the bill reflects that in terms of what it reduces and what it expands. And so in some ways, there needs to be some federal movement on this front in order to counteract these efforts we're seeing at the state level. But Congress does have to get its stuff together. If Congress doesn't, there's still the states, right? We still have the ability to go state by state and try to impact some of these efforts. Georgia did pass a law, but there are still grassroots organizations that are on the ground fighting these laws, trying to get people registered, trying to get movement in terms of opposing the new laws in order to prevent it from having maximum impact. So there are things that can be done. All hope is not lost, but I think it's important to understand that the courts will not save us.
So I have just 2 words in response to that. Joe Manchin.
Sorry. Did I say that out loud? I did.
So, it feels like on the one hand, it can't be a long-term winning strategy for a party to say, we're going to, we see the country is changing. And so rather than changing ourselves to reflect that change, we're just going to make it harder for people to vote. That in a democracy that can't be a long-term winning strategy. But when you look at the demographic trends in this country, and you realize, as has been predicted, that in 20 years, right? Many of the people on this call will still be, I don't think I still will be, but many of the people on this call will still be practicing law 20 years from now. And the Senate is going to be 70% of the population is going to be represented by 30% of the senators, and 30% of the population, those who live in the rural states, are going to be represented by 70% of the Senate. And of course, the Senate is critical to legislation like H.R. 1, and it's also critical to judges. So, where's the path forward given that reality?
So that's hard, right? Because the Senate is what it is, right? But it does raise the question of putting pressure on the Senate to be responsive to the whole of American democracy, right? So one way you can do that is having overwhelming majorities in the House that are supportive of voting rights, electing a president who then has a Department of Justice that's very proactive on voting rights, because the Senate, frankly, is hard to fix, right? But I wonder if part of this is that we just take it for granted, right? Like some of the failure to move on some of these issues and sort of place blame on the Senate, which is problematic. Like, I don't want to minimize that, is the fact that I think we've gotten complacent to some extent, and we just expect our democracy to keep moving along sometimes at a snail's pace, but still move along, that it'll exist. But if you study the entirety of American history, it seems like our commitment is not to democracy, but it's to democratic norms, which is a very different thing. Right. And because it's a commitment to democratic norms, and norms can be changed, and norms are dependent on democratic majorities and who controls the House and what they value, who controls the Senate and what they value, and so on, then it's very hard to argue that democracy requires certain things. And so in some ways, we do need to amend the Constitution to be more reflective of the fact that we want to be a democracy, that we aspire to be a democracy, and what our democracy should look like, as opposed to relying on democratic norms that turn on things like which party controls the Senate. Right? Because, for example, if we had a constitutional amendment that actually memorialized a right to vote, as opposed to relying on a court to interpret or read the Constitution to say that there's an implicit right to vote, I think that would go a long way towards protecting our democracy than our current system, where we do have to worry about shifting democratic majorities, and whether or not one party has a commitment to democracy and another party has a commitment to autocracy. And so, part of the problem is that our norms and our expectations are not mirrored in our governing documents. And that question of, what do we do with our anti-majoritarian Senate is a broader part of that conversation.
I think the first thing we ought to do is make DC a state so that I would have a senator in. Let me turn to Jamal. Jamal, you've just published this book, How Rights Went Wrong. I wonder what you've been thinking about the sort of history of rights in our republic. What advice would you have to, ACS folks about how we, seek to pursue our vision of rights, given what we face at the Supreme Court and the Court of Appeals?
Yeah, so I don't have easy advice. I guess that's why you've got to read the 336 pages of the book to figure out what I really think. But I think generally speaking, the book is about kind of reconciling rights and pluralism. And part of that reconciliation is keeping that kind of marginalized vision of what the Constitution and what the laws can be alive within the law. I think just in practical terms, one way of doing that in the current moment is to be thinking more about sort of passive virtues, thinking about ways of, and I'm reminded of what Fernita said about Section 2 of the Voting Rights Act, right? How do you lose less completely? You've got to strategize for that. That sounds really dark, but I think it's actually optimistic to think that that's even possible. as I look over the last several years, there have been examples of ways in which that's happened, particularly around Chief Justice Roberts, who I think has a very conservative set of ends, but is temperamentally interested in kind of off-ramps. He doesn't like kind of evulsive change. So constitutional avoidance as a mechanism, construing statutes in ways that may be a little bit twisted but avoid a constitutional holding. And we saw that with Chief Justice Roberts himself in the Wisconsin Right to Life campaign finance case. We saw it in Namudno, Northwest Austin Municipal Utility District case that was a prelude to Shelby County. We saw that in the Affordable Care Act case in Sibelius. Cindy talked about June Medical, where, and it's really the same dynamic where Chief Justice Roberts' opinion is a loss in the sense that he's redefining what the standard, what the undue burden standard looks like under whole women's health. But at the same time, by relying on stare decisis, is buying time, and time is really valuable when you're the out party, or the outside. You know, getting another 2 or 3 years, it may look like wolf in sheep's clothing, but the wolf needs to take some time to get that clothing off, and by then there could be political change. So that's really important. I think in addition to that, sort of thinking about ways in which you can transform facial challenges into as applied challenges. I think about Citizens United, and before the re-argument of that case, Chief Justice Roberts, again, at least this is through Jeff Toobin's book, right, suggested that he wanted that to be a much more narrow decision, thinking about compromised positions as the refusal of service cases. Maybe there are ways of requiring providers to provide suitable replacements, for example. Emphasizing remedial discretion. I think about this in the New York guns case. Think about a case like Parents Involved, it's just the school integration case from 2007, in which the court says, because you used race in the wrong way, we're going to just strike down your plan. What if instead of that, the court had said, we're going to suspend invalidity? We're going to say, it's unconstitutional, but we're going to give you, 6 months to correct or cure the constitutional problem. Maybe that kind of, putting those kinds of options on the table for the court. The New York guns case, that might mean, if you think this is unconstitutional, give us a chance to cure it. Don't just strike down the law. Those kinds of kind of delaying tactics, or keeping some responsibility in the hands of democratic actors. I think we need to be thinking in those kinds of terms when you're in this kind of facing this kind of majority against your position.
So playing defense.
Well, making defense your offense. Yes.
Yeah. That may well be right. I mean, a friend of mine is an environmental lawyer, and he often argued that in the Supreme Court, the game is about how is thinking through how you can lose in the least catastrophic way, and that's the inside game of how you're framing things before the Supreme Court. But that, of course, doesn't mean that you're constrained to that in the political realm outside, right, where you can still be advancing visions of constitutionalism that are going to be persuasive to people, that are going to appeal to people. And if at the end of the day you're able to succeed in convincing enough people that they're persuasive, you're more likely to both limit the losses in the court and change the politics so that you might be able to win some things in the court. So we have it's time to turn to questions from the audience. So I have many here that I'm supposed to somehow try to go through. But let me ask this one, which is about reproductive rights. And I guess the question is, what are we, if the court were to really free up states to make it difficult enough to get abortion in that state that for all practical purposes, you can't get abortion in that state. What are likely to be the avenues for other states to sort of step in and fill the void? Is that something that can be done with, much more easily with telemedicine? Is that something that the states will seek to preclude? Any thoughts on how telemedicine, the sort of pro-choice states helping out those who happen to live in anti-choice states? Cindy?
Yeah, well, I mean, I think that let me make the question a little bit broader, right? So if the sort of Supreme Court gets rid of the stopgap and allows states to start banning or greatly restricting abortion, I think what we're going to see is people will try to travel to the other blue states where abortion is still legal, right? But there are tremendous obstacles for people to travel, and it's really going to be a right that that's more available to people who have means, right? And I feel like this is one thing about the anti-abortion strategy of the Republican and the right, is that I think in one way they've been successful because it actually doesn't, the restrictions they've created thus far haven't really impacted wealthy middle-class people in the same way that it impacts other people. I think telemedicine creates an opportunity to make abortion available in states where it wouldn't be otherwise, in a way that wouldn't require travel. I haven't really thought about I would assume that states would ban the practice of medicine through telemedicine from someone from outside of the state trying to practice medicine in their state through telemedicine. So I'm assuming that they would try to make that illegal. And I think, again, what we're going to see is just self-managed care, right? That people are going to get abortion medication through the internet on their own, and we're going to see more people being criminalized.
Yeah, it strikes me that Europe is an example of this, where in Ireland for a long time there were very serious restrictions on abortion, but in England you could get abortion, and Ireland tried to prohibit clinics in Ireland from even telling women about their ability to get abortions in England. And ultimately, the European Court of Human Rights held that was an unconstitutional infringement on free expression, et cetera. So, there may be limits to what the red states can do in the era of telemedicine.
Yeah, and it's interesting, the Human Rights Committee that interprets the International Covenant on Civil and Political Rights talked about this issue of people having to travel for abortions, and actually looked at it on non-discrimination grounds, not just based on gender, but based on resources, right? That it's sort of discrimination against poor people to force them to have to travel to get an abortion.
Right. So, Fernita, I have a question about, isn't it true that a majority of Republicans are in favor of H.R. 1? And what do we make of the positions of Republicans in the Senate, given if that's true?
So yeah, I think that H.R. 1 is broadly popular. But in terms of the Republicans in the Senate, I think they're thinking about their reelection prospects, and the Republicans in the House as well. And that trumps any preferences that their constituencies have about what becomes law. And really that's a negative reflection of our system. The fact that so much legislation is dictated by the preferences of those in power as opposed to the preferences of the people. And this is also the downside of not having a court that effectively polices democracy or our political system anymore, because the court is no longer serving as a check against those the naked political sort of aspirations of those already in power. So And in fact, I want to invite you to revisit the Rucho decision from a couple of years ago. We're really going to feel the impact of that in this next round of redistricting, because the court essentially held that partisan gerrymandering claims are no longer justiciable. And so effectively, that means that not only can those in power ignore the preferences of their constituencies, they can now draw districts in ways that insulate them from being able to be held to account for how they vote on particular pieces of legislation. And so, our system really is in a situation where there isn't really an effective check on just naked partisan preferences.
So are we forced to give up on democracy or to sort of reduce ourselves to this sort of partisan divide in which it doesn't really matter what your principles are, it doesn't really matter what the arguments are, it just matters who it favors? Or is there a vision of democracy and what works and what doesn't and what's right and what's wrong, particularly with respect to access to the ballot, that we as progressives can sell to some of those 70 million who voted for Trump?
Right. So, some of this goes back to Katie's earlier point about playing the long game. Because you have to remember, we started off as a country where property white men could vote, right? And look at us now. It did take 200 years, but ignore that, right? Just focus on the point that democracy as a concept has been evolving, because even then, the slave owners who pretty much ran our system of government at least gave a mouthpiece to the democratic notions, even if we were living in a system that clearly wasn't democratic, right? But it did give us something to aspire to. And I think part of our job, those of us who, do this work, is to hold this country up to that ideal of we the people. And it may take decades, it may extend beyond our lifetimes, but we have to understand that democracy is an ongoing process, that in reality, we'll never reach the ideal, right? There'll always be somebody somewhere who can't vote, who should be entitled to vote, right? There'll be somebody who should be entitled to participate who can't. And so in some ways, we have to continue the fight on behalf of those people, understanding that we may never get to 100%, but the job is to get as close as possible. So democracy really is an aspirational project in this country. And I think over the last 200 years, we have been working our way closer and closer to the aspiration. Even if it's unattainable, ultimately, our job is to continue to move towards it.
So great. So I'd like to hear from each of you on sort of in some ways what I think is the ultimate question for so many folks who are attending the ACS convention, who are maybe starting out in their legal careers, and that is sort of in a challenging period, in a period where it feels like gaining ground is going to be a really tough ask, where the best you can hope for, often with respect to the Supreme Court, is the two words "cert denied." So how do you keep going? What motivates you to keep sort of writing your books, your articles, working with lawyers to try to advance a vision of justice in a forum, namely federal constitutional law, that is, seems to be moving in the other direction. So I don't know who wants to go first. Why don't I call on folks? Cindy.
I knew I was going to be first. I've been thinking about this question, and I guess there are reasons why I'm hopeful. I mean, in some ways, I think things are better in terms of the way people understand this issue of reproductive justice than when I started doing the work. I think there's been a tremendous amount of work to destigmatize abortion, right, in terms of just getting people to say the word abortion. But also there's been incredible organizing by reproductive justice activists, really, and this is from the time that we were in the wilderness, right, in terms of this chipping away and the organization by reproductive justice activists to sort of say, it's not enough to have Roe, but people actually have to have real access, and we also need to be able to choose to have children and to parent the children that we have in a safe and healthy environment. So I feel like sort of that organizing has been tremendous, and also I think the link of reproductive rights to other movements. I think, for a long time, people talking about abortion rights were sort of in a silo and not really working with people in other movements and thinking about the connection between reproductive justice and right to education, right to healthcare, right to immigration reform, like all of these things. I think there's more weaving together our movements, which is incredible. So, and I feel like we've actually seen, despite the bleakness of the court, we've actually seen real movement, right? We've actually seen the Women's Health Protection Act be reintroduced. We've seen actually the Biden administration drop the Hyde Amendment from the budget. The Hyde Amendment, which prohibits the federal government from funding abortion care, has been part of the federal budget since the 1970s. It was a no-starter even in the Obama administration, right? And so I actually think we are actually in a moment where our organization, hopefully, and the hard work of reproductive justice activists is really going to bring about some change.
Great, Jamal.
So as I've been sitting here listening in particular to a few things that Fernita has said, I've thought about that famous line that Mark Ruffalo gives in the Avengers movie as the Hulk, right? When he's asked, how are you able to make yourself angry? And he says, well, I'm always angry. And I've thought about that because in some sense, the progressive Constitution has always been in exile, right? It remains in a constant state of exile. I would encourage people to, as I do, to periodically read Robert Cover's famous Harvard Law Review foreword, Nomos and Narrative, and be reminded, right, that there always are multiple visions of the law and what the law can be. That's, I think, the idea behind Martin Luther King Jr.'s bad check, right? And the idea behind Frederick Douglass seeing an anti-slavery constitution, even in the 1850s. Courts exercise social control, right? But that's not the same thing as determining the content of the law. It's not the same thing as controlling legal meaning. And the law, as we want it to be, continues to live on. That's in some ways one of the lessons from that the left can take from the right, which has not abandoned its vision of the law and did not do so even when it was not politically ascendant. That the law lives on in these kinds of conversations like the ones that we're having right now. It also lives on in, much more importantly, in the work that all the people on this call and organizations like ACS do to build institutions in more congenial spaces than the courts, to try to win elections, to go to the other side of the law politics divide, to try to shape arguments that were once off the wall, like repealing the Hyde Amendment, and making them be on the wall arguments, so that once the political power actually does shift, then we're ready to go at that moment.
Thanks. Fernita.
Why do I continue to do this work is something I ask myself pretty regularly. And really the best answer I can come up with is that's what Black and brown people do in this country, because it's always been kind of this love-hate relationship, right? People, love Black culture, our music, the way we dress, but they hate Black people. And it's kind of been, an enduring tale. But I'm reminded of the fact that Black people in particular have thrived in this country despite all odds, right? It seems appropriate to reference the 100th anniversary of the Tulsa race riot, which was recently, and how a lot of people are discovering what happened 100 years ago in Tulsa, even though the story is pretty well known to minority communities. And in particular, the fact that Greenwood was destroyed by a white mob is important. But also important is the fact that Greenwood existed and it thrived. And you had Black doctors and Black lawyers and Black movie theaters and Black entrepreneurs who were able to thrive in a system of segregation and racism and discrimination. And that in itself, to me, is an act of resistance, right? The ability to be successful when the deck is stacked against you is an act of resistance. And so that's why I write, because I view it as an act of resistance. And there are so many in our community who continue to do that in every way imaginable, right? Joe Biden won this past election because Black people and brown people turned out and voted in Philadelphia. They voted in Milwaukee and Atlanta and all these other places. And, you know, Doug Jones won in Alabama because Black women turned out in large numbers and voted for him, right? So Black people, despite the fact that we have been mistreated by this country, we continue to fight for it. And so that's why I do what I do, right? I'm gonna force this country to live up to this ideal, even if they hate me for it.
Thank you, Franita. Katie.
Hard act to follow. I mean, I'll say I really just come back to many of the sets of ideas that we've been talking about throughout this panel. The idea that rights and justice and how the Constitution is going to be understood is not restricted to a particular moment of time, and it's not an arena in which the Supreme Court is the hero of the story, right? The hero of the story is all of those folks who are going out to vote, who are, doing the work in the trenches of litigating cases, who are, trying to persuade their friends and neighbors as to what is the right and just way to understand these very broad, concepts, equality, liberty that we've been given in the Constitution. And I think, viewing things from that perspective, it actually provides a very optimistic take on the importance of all of the work that not only the folks on this panel, but people in the audience, many, many others across the country, grassroots organizers, all of that is a part of what will build our Constitution of the future. And I think every piece of that is important.
Well, thank you. I want to thank all four of you for really fantastically thoughtful and insightful perspectives on the challenges that we face and how we can face them sort of, open-eyed, but with determination. I always come back to a quote that I read many, many years ago in a book by Cornel West and Roberto Unger. Book was called The Future of American Progressivism, and it was a very thin book. I guess the future of American progressivism was not very thick at that time, but it had this great notion. They say hope is more the consequence of action than its cause. As the experience of the spectator favors fatalism, so the action of the agent produces hope. And, what I've always taken from that is the idea that, it's not that you're born with a hope gene and therefore you act. It's actually the other way around. If you act, you produce hope. And if you sit back and you spectate, you produce fatalism. So you have, two choices. You can spectate and watch the world go to hell in a handbasket, or you could take action and produce hope. And I take heart from the fact that, organizations like this, like ACS, like the ACLU, where I work, are filled with people who are committed to taking action and producing hope. And so thank you all. Let me say a couple things at the end here. One is the all important second CLE credit code for those of you who are seeking such credit, and that is, I thought I had it here. I think it's next, capital N, next 7, the number 7. And then, and you have to put that on your form to show that you were here for the entire time, or at least you had the incredible ability to come in just when I gave you the codes. But let me also say, close with just a note in recognition of the passing today of Chief Judge Robert Katzman of the Second Circuit, just a truly great judge, a truly great man, someone who took action to produce hope. He really started the Immigration Justice Corps in New York, and which has now provided, I understand, over 90,000 immigrants with lawyers who otherwise would not have been represented. I mean, that is the kind of action that produces hope. So we just learned today of his passing, one of the great judges. So with that, I'll thank the panel, and I will turn matters back to Senator Russ Feingold.
So much, David and panelists. This really was a wonderful panel. I have to say, Fernita, your final statement was just enormously powerful and moving, and I thank all of you for the sentiments expressed and the ideas expressed. Thank you for helping us to once again demonstrate why courts and judges matter. I listened carefully. You talked about the Senate, of course, the Congress, the states, and their relationship with those other institutions. But in your discussion of the courts, you've provided me a perfect opportunity to highlight ACS's Path to the Bench project, which we actually launched in 2018. Our goal with this project is to utilize ACS's national and local networks to identify talented progressive lawyers and help them attain influential legal positions in the short, medium, and long term. Right now, we are, of course, particularly focused on identifying progressive candidates for the federal bench. And so we've developed 52 working groups across 39 states. It's a true grassroots effort, tasked with bringing together voices from every part of the progressive legal community in their area, and with intentionally reaching out to communities underrepresented on the courts, whether that underrepresentation is due to demographics or areas of practice. We believe that the judiciary should reflect the public it serves. This is why we're putting a premium on increasing the diversity of the federal bench. This includes gender, race, ethnic, LGBTQ, and professional diversity. We have actually, through this process, submitted hundreds of names to the White House, and I'm happy to say that even today, some of these individuals are being confirmed for lifetime key judicial appointments. We look forward to making sure that this grassroots work continues throughout the coming years. So this concludes part one of our programming today, but I strongly encourage you to take a quick break and then come back at 4 p.m. for part two, when we'll have a career development session focused on the various progressive lawyering opportunities during the Biden-Harris administration. Thanks so much for attending.